There's a knock at the door, interrupting your peace and quiet. It's a process server delivering a summons telling you that you've been sued by a debt collector. And if you don't know what to do next, your mistakes could cost you hundreds, if not thousands of dollars. And today, I'm going to take you through all the steps that you need to know about when you've been sued by a debt collector so that you can avoid mistakes and you can get total victory over your debt collector. The first and most important thing you need to do is when a process server gives you a summons and a complaint, you need to sit down and read the entire thing. The summons will have instructions on what you need to do next to avoid what's called a default being entered against you. And a default is just what it sounds like. It's like you never showed up at all and you lost before you even had a chance to begin. Because if you don't know how to respond to a lawsuit, the court is going to decide that you have given up your right to fight against your debt collection lawsuit. Every state is different, but here in Florida, there are 2 different types of summons, and each one requires you to respond in a different way. If you pick the wrong one, you're going to lose. So it's very important to make sure that you read the instructions carefully and make sure that you pick the right response to the summons that you've been given. I'm going to put on screen now an example of a summons from small claims court. And unlike most states, Florida's small claims court procedures do not require you to file a written answer. Instead, you're going to need to show up in court for your court date. And that's either going to be in person or it might be by a video conference like Zoom. Which one it's going to be is going to depend on your judge, it's going to depend on your court, and the instructions for how to appear are going to be listed in your summons. So the small claims summons I've got on screen now is requiring the defendant to appear in person in court at a particular date, at a particular time, in a particular place. And if that person goes to the wrong place at the wrong time, they risk losing their case. If they fail to show up, they risk losing their case. But what if you're being sued for more than $8,000? Then that lawsuit is not going to be in small claims. It will be either in county court or circuit court, and you're going to have to file a written answer to the complaint within a certain period of time. And if you fail to do so, just like if you fail to show up for your small claims court date, you're going to be in default. Now, looking at the summons here, it says you have 20 calendar days after this summons is served on you to file a written response to the attached complaint with the clerk of court. What that means is that once you get that summons in your hand from the process server, the 20-day clock starts ticking and you have to write a response and file it with the clerk of court. And when you file it with the court, you also have to mail a copy or email a copy to the lawyers on the other side of your case. It's important that you do both because if you do one but not the other, you risk being held in default. And again, that means you lose your case before it even starts. So it's important to read your summons and understand, do you have to show up in court? And if so, when, where, and how? Or do you instead have to file a written answer? And if so, where, when, and how? Once you've read the summons, and once you understand, is this a small claims matter where I have to show up in a court date, or is this going to be a larger lawsuit where I'm going to have to file something in writing, then it's time to read the complaint. That complaint will tell you what are the facts the debt collector is alleging and what is the legal theory that they are claiming that entitles them to recover money from you. Once you read the complaint and understand what facts and legal theories are being alleged against you, that's when you can start to form your defenses. That's when you can decide what kind of things you're going to put in a written answer if you need to file one, or if you're going to show up in person, what could you say to the judge that will help you defend your case? As you read the complaint, it will make reference to whatever documents are attached, and that's when you can decide which documents in the exhibits relate to which allegations in the complaint itself. So, for example, you might see that they attached statements of the account in order to establish that there is an account that was your account and how much was owed on that account. There'll be a particular portion of the complaint that references those statements and tells you why the debt collector is relying on them as part of its case. If they're attaching a contract, there'll be a particular part of the complaint that makes reference to that contract and tells you which exhibit it is. And then you can reference back and forth to see what particular type of contract they're claiming existed that they're going to hold you responsible for. And in many debt collection cases, the debt collector is going to claim to have purchased the loan from the original creditor or somebody else. And then they might be attaching documents like a bill of sale or other documents that pretend to show the chain of title of the account from the original creditor all the way through to the debt collector. So examine those and see if there are any breaks in the chain of title or if there are any gaps in what the documents are referring to with respect to your specific account. Now, if you want more details about how to break down and understand a complaint in a debt collection lawsuit, I've done a whole other video about that. I'm gonna put a link in the video description to that video so you can go into more detail about what the complaint says and how you can understand it better. Now, before I go to the next step, I wanna sit and acknowledge this part can feel really overwhelming. If you've never been to court before or you've never read legal documents before, this can feel like a lot. And if you're in Florida, there's a way for you to get Florida help for Florida cases. So I'm gonna put a link in the description that you can contact us, make an appointment, talk to one of our lawyers, talk about the merits of your case, whether it makes sense for you to lawyer up, bring in legal help so that you don't have to do this work, that it can all be done for you by people with experience who have done this before. So if you need help with a Florida case, check that link in the description. Now on to the next step. Once you've read the complaint and you've looked at the exhibits and you've had a chance to digest them, what you're going to want to do next is look for falsehoods. Look for things that the debt collector is lying about. What are the things that it is going to need to prove that it's not going to be able to prove because it doesn't really know? But they're pretending they do know, and they're telling the court that, even though they really don't. So what kind of things could they be lying about? We find that the number one most common legal theory, far and away above all else, that debt collectors will use when they go into court to sue people for debt collection lawsuits, they will use something called an account stated claim. Sometimes they'll label it that way, and sometimes it'll even be labeled account stated so you know what you're dealing with. But whether it's labeled or not, here's how you know you're dealing with an account stated claim. The debt collector is probably going to attach some kind of monthly account statement to the complaint, and then it's going to claim that the original creditor, the credit card company, the original lender, whoever that is, somehow provided that statement directly to the borrower. And the next thing that they're going to say in an account stated claim is that the borrower didn't object to that statement in time. If you see those two things listed in your complaint, whether it's labeled or not, you're probably dealing with an account stated claim here in Florida. Now, the interesting thing about those two allegations is there's no debt collector on the planet that actually knows if those things are true. They don't claim to have any involvement with this account until long after it was charged off. So how could they know whether or not the original creditor mailed a statement? How could they know whether or not you objected to it? The answer is they almost never can tell you that. They don't have any personal knowledge because they weren't involved, and they don't have any records that show that the account statement was actually mailed, and they don't have any record showing whether or not an objection was made. They're just guessing, but they're telling the judge that they know something for sure when they really don't. So when I'm looking at a debt collection lawsuit, I always look and see, does the debt collector claim to know whether somebody else did or did not do something before the debt collector got involved? And the answer is almost always yes. And then I ask myself, is there a way they could possibly prove that? And the answer is almost always no. So what does that mean? It means the debt collector is lying to the judge, pretending to know something for certain when there's actually no way they could know that at all. It's that lie that gives you the leverage. So if you've watched the other videos on this channel, you'll know that one of our favorite ways for responding to a debt collector is to find some way in which they've broken the law and then sue them back. And when a debt collector lies to the court, that is the absolute best way to hold them accountable for everything they've done. So once you've identified some way in which the debt collector has lied to the court about this case, about the debt, about the account, then it's your turn to strike back. When we found a way in which the debt collector has broken the law, we like to file a countersuit where we sue the debt collector for violations of law, and then we ask for money. And in most cases, when a debt collector is breaking the law, especially when you're in small claims court, they're going to owe you more money than they claim you owe them. So it's a great way to not only wipe out the debt entirely, but walk away with some money in your pocket. So generally speaking, there are three things that we look for when we want to file a counterclaim against a debt collector. First, you need to have an actual debt collector. This doesn't work against original creditors like banks or credit card companies. You need to have a company that bought the debt after it went into default, or somebody who's trying to collect the debt on behalf of someone else. Secondly, it needs to be consumer debt. What that means is for personal reasons or household reasons. If it's business debt, it's not going to count. And if you have business debt you're getting sued for, you probably need a business lawyer who can help you handle those debt claims in court. And the last thing you need is some kind of violation. And a false statement by a debt collector when they sue you is just the type of thing you need. Once we have all three ingredients, we put that in a counterclaim and we sue the debt collector back. And we sue them for more money than they're trying to get out of you. Now, if you followed all these steps before, you've got a great strategy for handling this debt collection lawsuit and turning it into a debt collection victory. If this is your first time in court and you're not sure what to say or how to write up your counterclaim in a way that's going to meet the court's requirements, you can get Florida Help for Florida cases. I want you to check the link in the description and contact us. If you're in Florida, we can help you sue your debt collector back and get your total victory. But if you want to do it yourself and you want to learn more about the account stated claim, which is the most common way debt collectors are suing borrowers here in Florida, go ahead and watch the video I'm putting on screen now. It's going to walk you through what an account stated claim is, what the defenses are, and most importantly, what the debt collector has to prove so that you know how to defend it and you know exactly what they're going to be lying to the court about. So thanks for watching. I'll see you on the next one.